Back. Alexander Napolin, attorney at large, goes live. It is 10:30 a.m. I said I'd be on at 10 o'clock yesterday, but I actually had some, it's a lot to do to kind of get this whole thing going. Anyway, I'm a licensed California attorney discussing current events from the legal perspective and also answering your questions in the chat. But remember that the information that I share with you on this channel is general in nature only. It is meant to help you, but it's not legal advice. If you need legal advice, you need to speak with a lawyer one-on-one and give them all the facts and circumstances of your case and then get the feedback from that lawyer. That's legal advice. So what we discuss on this channel is general in nature only. It's informational, but it's not legal advice. So don't forget to follow my channel and get notifications. I'll be streaming live every day between 10 and 11, and then again between 4 and 5. So today's story is, let's see here. Still having some technical difficulties here, flipping around. Today's story is about cannabis and medical marijuana in the workplace. So there's an article here, natlawreview.com, discussing Mississippi's new medical marijuana law. And this basically exempts employers from having to allow, or it specifically says that employers are not required to allow the medical use of cannabis on the job or to modify any job description of an employee who wants to use medical marijuana on the job. So it then goes on to discuss in this article the ADA, which is the Americans with Disabilities Act, which is a federal law that requires all employers in the country to provide reasonable accommodation for those who qualify under the ADA to have a disability. So does the disability require the use of medical marijuana? And can someone with a disability demand that the employer allow the use of medical marijuana as an accommodation? And under the Mississippi law, according to this article, they're not required to under the Mississippi law. And the ADA is a federal law, and marijuana, cannabis, is a Schedule I drug. So technically, in the employment setting, an employer can potentially terminate you if they find that you have tested for cannabis or you're high in the workplace. So that's the discussion for. Oh, I have a question. So here's a question coming in on over on Twitch. If I'm hurt at work and my employer makes me do a drug test and I'm terminated, what happens with my workers' compensation benefits? That's a really good question. So, what happens when you're injured at work is you often go to the health clinic, and the health clinic tests you, does a drug test. And maybe you have drugs in your system and you're terminated. You might be wondering if you still have workers' compensation rights. Now, I'm a California lawyer, so disclaimer, I'm a California attorney. I practice here in California. I cannot give you advice about workers' compensation issues in other states other than California. But if you are tuning into my broadcast here, I go live between 10 and 11 every day in the morning, and then again between 4 and 5, discussing in a current, let's see. Let me go over my spiel. Current events from the legal perspective, and also answering your questions in the chat. Remember, disclaimer, it's not legal advice. It's general in nature only. It's meant to help you, but it's not legal advice. So, if you're injured at work, you get sent to the medical clinic drug tests you. Can you be terminated? Can you lose workers' compensation benefits? Yes. If you test positive for drugs at the clinic after you've been injured, your employer can technically terminate you for a violation of a company policy. Okay? And this happens, and people get hurt, and now they have an injury, they can't work, but they're also terminated for cause. So most employers send their employees to industrial clinics that then provide work restrictions that are given to the employee to give to the employer for the employer to provide reasonable accommodation, for example, under the ADA, which we just discussed in this article, which was discussed in this article. So the employer will take those restrictions and try to find accommodated work. That's what they're required to do under the Americans with Disabilities Act. So if someone tests positive for marijuana or another substance when they go to the health clinic, though, the employer can say, well, I cannot take you back because you have violated company policy. Maybe that's why you got hurt in the first place. Maybe it's not why you got hurt in the first place. But for whatever reason, you violated company policy and we're not employing you anymore. We could provide you with accommodated work. We could provide you with work within the restrictions that the clinic, maybe you have a shoulder injury and you can't use your right arm. So you can oversee, you use your left hand to punch stuff on the dial when you are when you're doing your work or whatever. Maybe you can't stand for prolonged periods of time. You have to sit down sometimes because your back's hurting. Maybe you can only do sedentary work. Maybe you can't be out in the field for a period of time. Maybe the doctor at the clinic, because you're injured, you hurt your leg, you have to sit at a desk. And your employer says, well, we could have provided you with that work, but you tested positive for drugs and we have to terminate you for that reason. This happens a lot. So that's a way an injured worker can lose their right to temporary disability benefits because the employer is technically able to provide, but then there's a reason, a good faith employment reason why they cannot provide because of a termination. And if this comes up and you're wondering what your rights are, you need to consult with a lawyer because you might be in a different state. Remember, I'm a California lawyer. Disclaimer, this is not legal advice. It's meant to help you. It's informational. It's general in nature, which means I don't know all the facts and circumstances of your particular situation. So you can only get legal advice after consulting one-on-one with a lawyer and getting that feedback from the attorney. So the information I share here, it's meant to help you, but it's not legal advice. I mean, you're going to go and talk to an attorney. Maybe you hear me and this helps you in some way get more information about your rights. Maybe you are concerned because you've been recently injured and maybe they're going to drug test you and you're wondering whether or not that's going to affect your workers' comp benefits. Maybe you use marijuana and you're wondering whether or not your employer has to accommodate you. Well, according to this article in Mississippi, they do not. Now, I'm a California attorney and I do believe there's no required accommodation in California for cannabis use. I'm also an employer in California. So if you're in California, the law is no accommodation for cannabis. The employer is not required to allow you to use it, even if your doctor prescribes it. And also, if you do use it and you are drug tested, then the employer can terminate you for cause. And if you've been injured and that's why you're being drug tested because of a work-related injury, you could lose your temporary disability benefits if that's the case. And I have that happen. I have clients who are terminated for cause. Usually what we'll do at that point is help the client get on state disability. So if you're out there and you're watching this and you work in California, which I mean, I don't know where you work. You could work at a restaurant. You could work at an arcade at night. You could work in a business. You could be working from home. But you are supposed to be covered by workers' compensation insurance. So when I'm talking about your employer sending you to a clinic and maybe you're drug tested there, what I mean to say is you've been injured at work, you have a workers' compensation claim pending, and you're being sent to the industrial clinic to have your first treatment. Because if you're injured at work, your employer controls your medical care in California. It's like that in, I think, every other state in the country. But some other states, the systems are a little different. In California, we have lawyers that represent people who've been injured at work. That's one of the things that I do here. So going back to the article, this is what we were discussing earlier. We were discussing whether or not cannabis is cannabis, medical marijuana, if the employers are required to accept a doctor's recommendation for medical marijuana and allow the employee to use it as a reasonable accommodation for a disability. whatever that disability may be. Any disability triggered under the ADA. Now, I'm not going to go into those disabilities here because that's beyond the scope. We can do another day about what is a disability under the ADA. Maybe I'll do that this afternoon. If you want to tune in, we can discuss that. See if we have any questions in the chat. No. So earlier we did a question about whether or not you'd be terminated, how that affects your workers' compensation rights if you're injured at work and then you test positive and you're terminated. You test positive for a substance. So you can lose your temporary disability benefits. Now, maybe you can get all your other benefits. It's not that big of a deal. You get on state disability, you're getting better. Your employer still has to provide you with medical treatment. Your employer still has to provide you with a retraining voucher if you're injured permanently and that permanent injury stops you from performing your usual and customary profession, your job duties or whatever, your work. If your employer cannot provide you with a permanent accommodation, then you get a job retraining voucher. This is known as the supplemental job displacement voucher, vocational rehabilitation. It's like retraining. In California, you get $6,000 if your employer cannot provide you with a permanent accommodated position for your permanent work restrictions. Now, you're going to get those permanent work restrictions at the end of your workers' compensation claim. So if you are wondering, if you're hurt and you're wondering what to do, you need to call an attorney. Okay, so that's the morning stream. I'm going to be signing off now, going back to my workflow. Again, this is Attorney Alexander Napolin, attorney at large. I'll be signing off until 4 p.m. this afternoon. Don't forget to add me, follow me on Twitch, Facebook, YouTube. Request notifications so when I go live this afternoon, you can hop in the chat and ask me questions about what we just discussed in the morning. I practice in California. Remember, it's not legal advice. But if you need to speak with me, if you want to speak with me about a situation, give me a call, 866-NAPOLIN. And my practice areas are like personal injury, workers' compensation, stuff like that. Injury law, bankruptcy, family law, estate planning, and medical malpractice matters. So if you have any of these types of situations, you can give my office a call. I'm a California attorney. If you're in other states, then I can maybe help you, guide you in the right direction. Remember, it's not legal advice, what we discuss on the station, on the channel. It's general information only. You can only get legal advice by speaking one-on-one with a lawyer. So if you need to speak with a lawyer, you're hearing my live stream, you're saying, oh man, I need to speak with an attorney about the situation, then give a lawyer a call. If you're in another state and you want to call my office, we can maybe help you find an attorney that you can trust. That's something that I can help you do too. Anyway, signing off until 4 p.m. and going to check out the stream, see how it went. I don't think I had any viewers on some of my platforms, but looks like we got some engagement here. All right, signing off.